Good morning, everyone. Thank you for attending our webinar this morning. It is 9:30, so we're going to head and get started. My name is Erin Kopek, and I'm the Marketing Director for Extra Help, a workforce management resource. You have joined us today for our Workplace Excellence webinar entitled EEOC Ban the Box, and you will get your questions answered today. Brian Chapman, founder of MBI Worldwide, will be introduced and begin momentarily. Just a few things before we begin. You are set up as listen-only mode, so you will be able to pose your questions at the question or the chat function at the bottom of your screen. Feel free to ask those questions throughout the webinar, and I will relay those to Brian. The call will last about 1 hour, and let's get started. So Brian Chapman, he is the co-owner and the founder of MBI Worldwide Incorporated, a company specializing in the pre-employment screening industry for businesses all over the country and internationally. He is one of the founders of the National Association of Professional Background Screeners and sits as a board member on the NAPBS Accreditation Council. Brian, thank you for being our presenter today, and I will turn it over to you.
Hey, thanks, Erin. I appreciate you letting me help out here today and kind of present this. Again, I'm Brian Chapman. I'm the founder and co-owner of MBI Worldwide. We're a consumer reporting agency, and what we do is background checks and drug screening. We've been in business about 18 years, so we've been around the block a few times. I am a founding member of our national association, which is National Association of Professional Background Screeners, and I sit on the chair for our accreditation committee, which what we do is we have like an ISO type certification where we accreditate other background companies. Currently there's 60 background companies that have our accreditation, which again is similar to ISO. It takes about 1.5 years. And I'm on that committee that evaluates those other background companies. I'm also have advanced certification in FCRA, which is the Fair Credit Reporting Act. And let me explain about background companies. We are not really private investigators. We are a consumer reporting agency, which is the easiest thing to compare it to is a credit bureau. TransUnion, Equifax, Experian, they are a consumer reporting agency. We are also, and so we do the same thing they do. We collect information, repackage it, and give it to you to make in your case, a hiring decision. So that's how we're regulated by the federal government, and that's so the FCRA, Fair Credit Reporting Act, is kind of our Bible and what we go by and how we manage accounts and end users and applicants. So there's lots of laws, lots of litigation involved in making sure everything's right and correct. And so today I want to present a couple things to keep you guys aware of what you need to be doing internally in your company and when you hire someone and run a background check. Other things you can do, we have a blog right there. You can write that down. Follow us on our blog, on our website. We write usually at least 2 to 3 blogs a week on something trending, in our industry and human resources. And our LinkedIn page, follow our LinkedIn page for our company, and same thing, we post a couple times a week. Usually it's about an industry trend, or it could be something funny, but anyway. Explain to you what CRA is. So today I'm going to try and talk to you about how EEOC is regulating the background check industry. I can't flip this page, Erin.
All right, give it another try.
Well, I can't get it to go.
All right, try it again.
Oh, there we go. Okay, good. Equal Employment Opportunity Commission, everyone knows what that is. They have lots of hot topics, but the hot topics I'm going to talk about today is just involving hiring. What they're telling you need to be doing during the hiring process and promotional process. We're not going to cover anything EEOC talks about, firing or anything during work. We're just going to cover hiring and what they've done recently and what they want you to do. So Today's topics, we're going to have 3 of them. Basically, about the EEOC, their enforcement guidance, their opinions on how background checks they believe create a disparate impact on minority groups, and I'll explain that, and then what they want their process to be during hiring and running background checks, and even during the application process and interview process. The next subject we're going to discuss is just ban the box. That's a hot term going around right now in all the states, and that is related to the on the application, whether you have when you ask if they have a criminal history. And there's a lot of energy toward that right now, and I'll tell you what's going on in the states. And then, of course, adverse action. Hopefully you've heard about adverse action, and I pray that you're doing adverse action. You have a policy on it. And adverse action is, if you're not doing it, you start today. So this is adverse action is probably the most important thing you could learn from this webinar, and I'll cover that in detail in the last part of it. Definitely something you need to be doing is adverse action. So, EEOC enforcement, they definitely are out to minimize disparate impact on minority groups during the hiring process and, of course, during employment. They made the decision probably really during this administration to enforce and regulate hiring pretty heavily. They've done a lot of things in the last 4 years to get involved in that and have businesses and human resource departments change the way they do it. They do have a special emphasis on the background check process and how it affects minority and second chance applicants. And when I talk about second chance applicants, I'm meaning people that come out of prison that have been convicted. President Bush passed a law during his term to help, it's called the Second Chance Act, to help convicted felons come out and integrate in society a little easier. The President Obama has expanded on that quite a bit and has asked his government entities like the EEOC and the Consumer Financial Protection Bureau and some other agencies, Federal Trade Commission, to help that even more, to minimize the effects on convicted criminals when they're trying to get reintegrated into the job force. So in 2012, the EEOC created the background check guidance, and I'm going to explain that in a second here. But I want to tell you about the most recent win for EEOC involving background checks. And this is actually their only win so far. There's about 1,000 different lawsuits, civil lawsuits that they've put against employers. But this one is their big win. This came out in October against BMW, and this was a long-term litigation that they were involved in. It was about a 2-3 year deal. BMW finally gave up. They were tired of fighting it. And they entered into a consent decree with the EEOC. So the reason I want to talk about this is that EEOC is going to use this as a standard bearer for the next couple of years on your workplace and on your human resource group to create new policy on. BMW ended up agreeing to pay $1.6 million to 58 applicants that they turned down for jobs because of their criminal history with their old policy. And their old policy was similar to a bright line rule of, we take no felons. Well, so they turned down a lot of applicants. Well, now they have to reimburse them money, and they also agreed to make these policy changes. This is a court case if your legal counsel wants to look at it, but surely if you have an employment law lawyer, they probably already know about this. So these are some of the bullet points on this case. The BMW can no longer use criminal arrest records to decline employment. And so what that means is there's arrest and conviction records. I mean, they're only allowed to use conviction records. Now, industry standard is, for the last 7 years, you're allowed to use arrest records as part of your decision. Anything beyond 7 years, you cannot use arrest records, only conviction records. But in this case, BMW agreed not to use arrest records at all. So I think this is going to be probably a new standard for EEOC when they come into your facilities. They provide written notice to applicant identifying their offending criminal history information and request additional information from the applicant for hiring. So meaning they want BMW to call the applicant and say, hey, we found a criminal history, we'd like you to explain it. Come on in, tell us about it, tell us what happened, so we can make a decision before them making a non-hire decision. And as well as that does happen, they have to hold a position open for 21 days, which is forever in the HR world. Most of you know that. And then have an official review of all decisions not to hire prior to make a final decision made. So an official review, meaning they want, which we're going to talk about a little bit, they want a committee of people. Right? So if you have a larger company, they want 3 or 4 people reviewing this at once and making a team decision not to hire this person. If you have a small company, EEOC wants you to have your CEO make that decision, as well as the HR person. So it's not just one person making these decisions that may have some kind of discriminatory factors in their background, or may have a, maybe they don't like truck drivers, so they're not going to hire truck drivers. They don't want those kind of decisions. They want several people making this no hire decision. And this is an interesting one. They want BMW to create a database of individuals excluded from hire and then give that list to EEOC so EEOC can look at it. So basically they have to justify why these people are not allowed to work at BMW. And then of course training staff on the new policies. And then part of the agreement is you have to offer employment to all the prior people they already turned down under the old policy. So this is definitely going to be, EEOC is going to push this in the next couple of years for all employers to do something similar to this. The EEOC guidance I was talking about is something that came out with 2012. It's about an 80-page document that the EEOC committee in Washington, D.C. came up with. Now, the interesting thing about this committee, there's only 5 members of the committee. Now, there's literally hundreds of EEOC offices and thousands of employees. There's only 5 bosses, and they're in Washington, D.C. 4 of those committee members were appointed by President Obama and 1 by President Bush. So this guidance came out, and they didn't ask for anybody's advice or opinion. They didn't go to Society of Human Resource Management. They didn't come to us, NAPBS. They didn't go to the National Chamber. They just started creating this guidance, what they think we should do for background checks, or what you should do for background checks. We ended up finding out about it, so the National Chamber, SHRM, and NAPBS tried to get in and have some meetings with them, and they basically refused to meet with them. Only 1 committee member agreed to meet, which was the one appointed by President Bush, and then she didn't have enough influence to make any majority changes. So we kind of got stuck with this guidance. So I'm going to tell you what the guidance is and what you should be doing inside your companies. And their excuses for the guidance was, they thought a lot of databases were incomplete, and they're incomplete, and some criminal records are inaccurate, which that's probably a true statement. There's some inaccuracies, especially when it comes to expunged records. Applicant may have expunged their criminal record in one area, but then get expunged somewhere else, and a company like us can find those things. But there's actions, which I'll explain, in adverse action that you can take to still fix those. And again, EEOC has a strong belief, and there is some accuracy to it, that African Americans and Hispanics have definitely a higher conviction rate than other populations, and so it creates. So when you don't hire based on criminal history alone, then it creates a disparate impact on those 2 minority groups. So EEOC is just trying to fix that. So the guidance discourages employers. One of the things discourages employers from using blanket exclusions of individuals who have been convicted of crimes. So that is, again, so there's no disparate impact. They don't want you to say, okay, if you're a felon, you can't work here. They definitely don't want that, and you should. Hopefully you don't have that in your policies now, and if you do have them, get them out, because that's the first thing the EEOC is going to look at, is that policy of, do you hire people with criminal histories? Because if you don't, then you're having a disparate impact on the minority groups, which is why I banned that box effort. So is so high, because if you just take your applications and throw away all the ones that say I have a criminal history, then again, there's a disparate impact on minority groups. And then the guidance, they want you to be consistent. And this is actually a quote from EEOC. For example, employers should consider whether they're ignoring drug convictions against young white job applicants, writing them off as youthful experimentation, but jumping to conclusions that drug convictions of young black candidates suggest something more sinister, like drug dealing and gang involvement. So they're wanting to, everybody to treat everybody fairly. So these right here are kind of the bullet points. So this is a kind of a simplistic way to be compliant with the EEOC. So when they come in your office, these are the things they should be seeing. And if they see these things, they will like you and not go and not search for other things. So this is a big one right here. Employers may not have a blanket no hire policy or it's called the bright line rule, meaning no felons work here. That's a bright line rule. You should not have that anymore. Or they want you to use a matrix. They want you to create a matrix, which means you set up a matrix of crimes that you think shouldn't be in your workforce, which, if you're a factory, a guy that's convicted of embezzlement could easily be working on a factory line stamping valve covers. So there's nothing to do with that. So that matrix, but the guy stamping valve covers hopefully doesn't have 4 convictions for aggravated battery. I mean, you can't work with people working with the guy in the line next to him. So that's something that you could be looking at in your matrix. And then employers should use a committee board member to review do not hires based on consumer report. Again, back to the committee review, the team review. So if you're an HR person, an HR assistant, maybe somebody in accounting or another manager coming together and making decisions on who you don't want to hire and justify that there's more than one person making that decision. And that will get rid of any discriminatory assumptions from the EEOC. And then employers should review applicants as an individual. Again, back to assessing these applicants individually. So again, no blanket rules. You're not just getting rid of them at the application process. You're bringing them in to interview. You interview them, you get your feeling about them, you look at their resume, and then you ask about the criminal history. Now you have that. So now you have all 3 of these things, a package of things to review. So then you review it individually with your team. So here's the individual assessment factors EEOC wants. So they want to know, they want you to review the facts, circumstances of the offense or conduct. And we can say a criminal damage to property. And say a felon that's a criminal damage to property, he got that felony because when he was in college, he was in downtown, some college area where they were all drunk and being dumb, and they flipped a car over. Well, he got arrested for a felony criminal damage to property. Him and 25 other guys. Well, in the same sense, a criminal damage to property felon where a boyfriend goes to a girlfriend's house and lights the car on fire. Totally 2 different circumstances, 2 different conducts, and they want you to review those to see what they were and make a decision after you understand what the arrest was for. The number of offenses. So a guy that has 4 convictions compared to a guy that has 1 or 0 is different, than a guy who has 1 conviction or 0 convictions. The age of the offender. A 25-year-old with 3 convictions is much different than a 50-year-old with 3 convictions. Totally, 2 different circumstances. So you're evaluating his age. Evaluating his post-conviction employment experience. So after he's been convicted, what's he doing? Is he still a bad guy? Not working, job to job to job to job? Or does he have a good employment job, whether it's in your industry or something similar, and he's been there for 4 years? So he's a good guy now. That's something to evaluate, which goes along with the second one. Any rehabilitation, education, training, college degree, any other things he's done for himself to improve himself as a person. And then, of course, if he's bonded by an insurance company, that definitely, shows that, he's probably fairly decent. So these are the assessment factors you need to be looking at and setting up in your policy. If your attorney doesn't have you doing this, you need to call them and get this kind of away. This is the first thing when the EEOC comes in your office they're going to look at. Just look at your policy on your hiring and your, what I'm going to talk about later, your adverse action. So if hopefully you have some kind of attorney that helps your company, and make sure the attorney understands employment law. If they don't understand employment law, have them talk to the consumer reporting agency, which is us or whoever you're using, because we definitely know how to do these things and what's going on with it. Have them talk, because every attorney doesn't always know what's going on up to date. They're busy. We had a situation once. We had an employer had this attorney that was probably in his 60s, had been their attorney for 40 years, contract guy, knew nothing about employment law, got them in a lot of trouble. I ended up having to get my attorney on the phone with them to convince him of actually it was an adverse action situation, convince him to do the things we need to be done. So make sure your attorney is bright and on top of things. All right, ban the box. So we're changing subjects, ban the box. Nationwide, over 100 cities and counties have adopted what is widely known as ban the box. So that employers consider jobs candidates' qualifications first, without the stigma of a criminal record. These initiatives provide applicants a fair chance by removing the conviction history question on the job application and delaying the background check inquiry until later. So this isn't, well, in some states it's law. EEOC is definitely pushing it. So my opinion is if you don't already have that question removed from your application, go ahead and remove it now, because it's going to happen in the next 12 to 24 months. Just remove it and then do it later after either you interview them, then you can ask about their background check, or after you make them a conditional offer of employment. Sorry about the way this looks, but I couldn't get a good color here. But these are the states that have adopted ban the box already with passed laws. 19 states have passed laws, as well as, like the previous slide said, hundreds of jurisdictions. I'm actually in Florida, so in Florida, Jacksonville, Miami, Fort Lauderdale, Tallahassee, Clearwater, St. Pete, Tampa, they've all passed city ordinances banning the box for employers inside that employ inside their city. So same with these states here. The ones that have, most of them have banned them, they've usually banned them with government offices first. So any government employees, government offices have to remove the box. And then what these states have done have come back and passed another law banning it for private employers within their state. So right now, the private employers who banned it within their state is Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, Oregon, and Rhode Island. If you're in those states, you have to remove that from your application. And when I say applications, I also want to include applicant tracking systems or your HRIS systems or your cloud systems. Remove it from those two online. So make sure you're doing both paper and cyber. Oh, I'm going to tell you, if you have questions while I'm doing this, go ahead and type them out. I'll try and catch them and answer them while I'm talking here. All right, next subject is adverse action. So if you're not doing adverse action, start doing it, because this will get you in trouble faster than anything. Basic adverse action notice is a letter you write the applicant once you want to deny them employment, once you want to take adverse action against them. So based on their consumer report. So this is the same thing you get when you apply for credit at a car dealership or credit card, and you get denied for that extension on a credit card, or you get denied for a credit card, denied for a car. The Equifax, TransUnion, or Experian will send you a letter saying you were not approved for credit for whatever reason, your credit score. You can get a free copy of your credit report here to evaluate whether it's accurate or not, and then you can make a complaint about the credit report. Well, it's the same thing in our industry because we're regulated the same way. You send a letter to the applicant saying they're denied because of their criminal history, and then you give them our information, and then we help them if they want to complain about it. So I'm going to tell you the steps you need to take for adverse action right here. So the first thing on the left is legal requirements, is your consent forms. So you have to start out no matter what, when you hire somebody, you have to sign a release, a consent or authorization. That release has to be a separate piece of paper, not on the application. If you have on the application, you, dear applicant, you're authorizing us to run a background check on you. Take that off, get rid of that, because it's not going to work. You're going to get sued. It has to be a separate document now, a special consent disclosure form saying they're authorizing you to run a background check on them and check their work history and their education. No, you cannot. Back in the old days, we all put indemnifications on the form, meaning we're going to run a background check on you. You hold harmless. Me, you hold harmless. My background provider, you hold harmless. All the county courthouses, wherever we get information from, you hold all them harmless. The courts have definitely defined you can't do that. So take all those off because you'll get in trouble. And then nothing extra on the disclosures. No EEOC statements, no fair housing statements, no we are a great company statements, no, nothing like that. Just they want it simple, concise, so the applicant understands the consent. He's not confused by it because it's already confusing enough. So they want nothing extra in these consents. If there's something extra in it, what we're seeing is a lot of lawsuits, including class actions, where they're coming after you for confusing your applicants and they don't understand what you're doing. They don't understand why they got denied employment. So keep them simple and concise. Try and get those from your consumer reporting agency, or get them, make sure your attorney has changed them. 2015, there's new wording, so make sure they're updated for 2015 standards. If you have an old one that's 3 years old, trash it and make sure you're up to date. So that's the disclosure. You run a background check, and then you want to you don't want to hire them. So this is the second stop, procedures of the adverse action process. So the first thing I give them is pre-adverse action notice. It's a simple one-page letter or email or even a verbal to them saying we're looking at a report. We don't like what's on it. It doesn't fit our qualifications. Here's a copy of it. If you dispute any of it, please let us know within 5 days. So this is called a pre-adverse action notice. It means you haven't made a decision yet. You want them an opportunity to do a rebuttal. So in that letter, you have to add in the summary of rights, which is a Federal Trade Commission document, the notice in the envelope. So you want to do the pre-adverse action notice. It's basically 4 sentences, and then a copy of the consumer report from us. Then you give them a minimum of 5 days to do a rebuttal on it. We're recommending 7 to 10 days if possible, if you can hold that position open. If they don't do a rebuttal, then obviously it's accurate, and you can go ahead and give them the adverse action. Based on your consumer report, we've decided not to go any further with your application, and you're no longer qualified for our company. That's the adverse action notice. 2 sentences, nice and easy, but it's giving them notice. So this is required. If you're using a third-party company like us to do a background check, this is required, and you will be sued if you're not doing this, and you will be fined by EEOC if you're not doing this, and by the Consumer Financial Protection Bureau. If they find out, they'll also do that. So make sure you got some kind of policy set up on this. Even if you hire everybody you bring in, still have a policy on that you're doing this. In case they come in, they're going to ask to see these policies. So your obligations is to have all these documents in your coffers. You have to have our information, or your consumer reporting agency's information, which is their 1-800 number, their contact information, and then their address. So the applicant can send a letter, call, and do a rebuttal on his consumer report, just like the credit bureau does. We suggest you have a written policy set up for all these, and then definitely create a review team to evaluate these no hires. So, any questions so far? Okay. Obviously, we all know compliance is the key. The plaintiff's bar has figured out this is a great new place for them to attack and to make a quick buck. Most of the time, if they get a client from, they've been denied improperly, it's about 20 grand you're going to pay them. Or if it goes into class action, if the lawyer figures out that you're doing this consistently, you've done this to several applicants over the last 3 years, he'll file a class action, which of course will cost you lots of money. So make sure these are all documented, make sure you're doing all these right, because right now there's hundreds and hundreds of lawsuits right now out there. So this is what's happened in 2015. I've talked about BMW already. Kohl's just got their case dismissed, but they fought it for 2 years. So I have no idea how much they spent on lawyer fees, litigation costs, but it was a lot. Calvin Klein just did an out-of-court settlement for $700,000 on adverse action. They weren't doing adverse action properly, so they ended up. That was the out-of-court settlement. Amazon right now is in the middle of a class action that was filed in April, and it's actually they had a staffing company doing their hiring, and the staffing company wasn't doing adverse action, and so Amazon's being sued for it. So make sure your vendors are all proper as well. So I got a question here: how are hiring decisions different for contract roles when often a client company sets a policy? I don't really understand that question, but it may have covered it just now. Okay, good. Next slide, let's see. Try and get the next slide here. There we go. So my recommendations for you guys, definitely review your background check consent forms. A thorough review of these forms will help avoid these types of claims, including, again, your applicant tracking systems. If you have a cloud-based system doing applications, make sure those are changed as well. Sometimes people forget to tell your IS department to change those. So change the wording in your ATSs to make sure they're compliant on the consent forms. Employers should implement procedures to help ensure that adverse action notices are sent at least 5 business days after the pre-adverse action. Again, I'm recommending 7 to 10 days if possible before you send the actual adverse action. And then you should consider how to best record personnel decisions that the employer can prove that the reason applicant was rejected was because of a poor interview, a failure to provide follow-up information, a drug test, rather than based even part on the background report. So document, meaning if they weren't hired based on a background report, make sure you document why they weren't hired, because EEOC will assume it's on the background report. And they will assume you're doing a disparate impact on minority groups, and they will come after you for it. So document the reason you didn't hire them. If it was because you didn't like their hair color or whatever, just document it. Make sure they don't assume it's based on the consumer report. Review your background screening policies with HR director, company counsel, and your CRA. Include your background company because they know more than your attorney does right now. We are so involved in this because we don't want to get sued either. We are doing things every week. We're doing webinars ourselves within our association. I have the best attorney. She actually meets with the EEOC in DC on a monthly basis. So we all have great attorneys representing us for these new policies, litigation. We have lobbyists that tell us what's going on right now. As of yesterday, what litigations are out there. That's how I was able to get the list of ban-the-box states. So we are up to date, probably more than your counsel is. So make sure we're involved with that somehow. And obviously none of us charge for that because we're already giving you a service for just providing the background checks. But we're more than happy to help you get compliant for sure. So in conclusion, even a cursory review of the class action filings from 2015 reveals that the storm clouds are gathering under FCRA. Thus, the investment by you in fortifying your compliance is likely to pay big dividends. So just make sure everything's in order. So we'll help, extra help. If you're using them for your services, they'll help you. Just go with your vendors, or they'll definitely help. So basically, stay sharp. Follow us on our LinkedIn page. If you have any questions, you can email me separately. My email is at the beginning of the slide. It's bchapman@mbiworldwide.com. Or ask Aaron or anybody else you want. We'll give you some questions. Aaron, that's all I have.
All right. We can give you another minute. If anybody on the webinar today has any questions, please feel free to type those in the box. Again, another minute, and then we'll wrap up. All right, looks like there is a question coming in. It says, we are a financial services company, total white-collar jobs. We don't do criminal background or drug tests prior to hiring. How much risk do we face in hiring now?
How much risk what?
How much risk do we face in hiring now?
Well, you're going to get the risk now. It falls on your co-employees and anybody that they deal with on the street. So when a customer finds out you're not doing background checks, that's where the risk is. Or if something happens within your agency, in your company, to a customer or to a fellow employee, that's where your risk is now. So there's another risk. And when people find out you're not doing background checks, especially if you're dealing with their money, if it's financial, that's just going to be really a marketing nightmare. People know when you're not doing background checks. Because again, all the white-collar crime, embezzlement, etc. So it's a different risk, and that's the decision you have to make. Which risk are you going for? EEOC won't say anything because you're not creating a disparate impact, because you're not doing background checks. But the risk is on the other side with your customers and when people find out about it publicly. Okay, anything else?
All right, I don't see any other questions, so that ends our webinar for today. Thank you all very much for sitting in, and thank you, Brian, for presenting to us. Great information.
All right, thank you very much.
Everyone have a great day.